In this video of the lesson, Legal Principles of an Insurance Contract, we will be discussing the special features of an insurance contract. Apart from the essential elements of a contract, insurance contracts also abide by special principles mentioned herein. The concept of humorema fides is defined as involving a positive duty to voluntarily disclose, accurately and fully, all facts material to the risk being proposed, whether requested or not. Proposer has a legal duty to disclose all material information about the subject matter of insurance to the insurers who do not have this information. If utmost good faith is not observed by either party, the contract may be avoided by the other. Material information includes one's own medical history, family history of hereditary illnesses, habits like smoking and drinking, absence from work, age, hobbies, financial information like income details of proposer, pre-existing life insurance policies, occupation, etc. Material fact has been defined as a fact that would affect the judgment of an insurance underwriter in deciding whether to accept the risk, and if so, the rate of premium and the terms and conditions. We have already discussed in the earlier slide about the material information that one should disclose. There are certain material facts which the proposer is not obligated to disclose, unless there is a specific inquiry by underwriters. These are measures implemented to reduce the risk. For example, the presence of a fire extinguisher. Facts which the insured does not know or is unaware of. For example, an individual who suffers from high blood pressure but was unaware about the same at the time of taking the policy. Facts which could be discovered by reasonable diligence. Matters of law. Everybody is supposed to know the law of the land. And facts about which the insurer appears to be indifferent or has waived the need for further information, the insurer cannot later disclaim responsibility on grounds that the answers were incomplete. Breach of good faith can arise either through non-disclosure or misinterpretation. In case of life insurance contracts, the duty to disclose is present throughout the entire period of negotiation until the proposal is accepted and a policy is issued. Non-disclosure may arise when the insured is silent, in general, about the material facts because the insurer has not raised any specific inquiry or gives evasive, inadvertent answers to queries raised by the insurer. Misrepresentation can be of two types. Innocent misrepresentation, which relates to inaccurate statements made without any fraudulent intention. And fraudulent misrepresentation, which refers to false statements that are made with deliberate intent to deceive the insurer. An insurance contract generally becomes void when there is a clear case of concealment with intent to deceive or when there is fraudulent misrepresentation. The expression fraud means any of the following acts committed by the insured or by his agent with the intent to deceive the insurer or to induce the insurer to issue an insurance policy. A. The suggestion as a fact of that which is not true and which the insured does not believe to be true. B. The active concealment of a fact by the insured having knowledge or belief of the fact. C. Any other act fitted to deceive. And D. Any such act or omission as the law specially declares to be fraudulent. Note that in the case of fraud, the onus of disproving lies upon the beneficiaries in case the policyholder is not alive. Insurable interests is the basis of contract. The existence of insurable interest is an essential ingredient of every insurance contract and is considered as the legal prerequisite for insurance. Subject matter of an insurance contract is the insured's financial interest in that property. It is only when the insured has such an interest in the property that he has the legal right to insure. For example, in gambling, one could win or lose, but in a fire, one can have only one consequence, loss to the owner of the house. The owner takes insurance to ensure that the loss suffered is compensated for in some way. The interest that the insured has in his house is termed as an insurable interest. The presence of insurable interest makes an insurance contract valid and enforceable under the law. In life insurance, insurable interest should be present at the time of taking the policy. Thank you.